What is going on, everybody? This is Mark Reel, the Father's Rights Attorney, with another episode of the Father's Rights Playbook. And on today's episode, we have Senior Trial Attorney at Real Father's Rights, Shannon Wright. Shannon, how are we doing today?
I'm doing really well. How are you doing?
I'm good. And so we talked a little bit off camera. We're going to dive into kind of what men should expect with probably the most common thing we do, which is defending domestic violence restraining orders.
Yes. What I first look at is we need to address what is it that they're accusing. Because oftentimes, even though men are probably pretty close to evenly statistically wise as being victims of domestic violence, they're not the ones who file a lot of times, which I would personally like them to get out of that mindset and start filing if they are victims. They have to protect themselves and their children. But most often what we're dealing with is that the woman is more likely to file against the man. And so that's usually what we're dealing with.
Yeah. I think some of the common statistics that I've read, that I've heard, it's a woman will be a victim of domestic violence, physical domestic violence, 6 to 7 times before she reports. A man will be a victim of physical domestic violence 15 times before they report.
Well, and so often what I hear from a man, whether it's being our client or somebody else I'm talking to, their first thought is, well, I don't want to report her. I don't want to get her in trouble. I don't want to take her away from our kids. And they're more concerned about her than they are about their own safety physically, mentally, emotionally.
You think about roles. I think it goes back to kind of gender roles, is even in those situations, even when divorces get as nasty as they come, the man still feels an obligation to be the protector.
Yeah, and
I think women women are infinitely more likely to kind of pull the nuclear option, where the man is still, even going through a nasty divorce, viewing themselves and feeling like they need to be the protector.
Well, and what I really try to drive home with our clients, especially if there's children, is that you're not just looking out for yourself, you're looking after your children. You need to protect them from her. Yes, you know, she might get in trouble. She might, there's a rebuttal presumption that she should not have the children, but the children should not be continuing to be exposed to that domestic violence. They should not be the ones learning that it's okay for someone to treat their father this way, to treat them this way, to have this environment for them. Mm-hmm. And if I could do one thing, I'd like to shift the men's mindset, keep that protective mentality, but see that it's their children that they really need to be protecting and not the abuser.
Yeah. I think it goes back to, I think that if you look at 90%, it's something like 95% of restraining orders in California are requested by the woman. And I think it starts out with, and I'll let you kind of explain to the listeners, we have in California, and even as of 2020, we expanded it further, this crazy broad definition of domestic violence. And I think that every single restraining order I've ever seen from men has been serious physical domestic violence. I would say that probably, 75% of our cases, the lead allegation is nothing physical. It is everything emotional. So for the listeners and viewers and these men that may be victims of domestic violence, according to the state of California, like, what are some of those things? What is domestic violence to family courts?
Well, domestic violence, and to explain how it is to family courts, I need to at least address what it is in criminal courts.
Perfect.
So in criminal courts, it is down to just the physical. And the relationship to the person is similar. It is expanded in family court for the restraining order, but in criminal court, it's only about the physical violence being exerted or the threat of physical violence being exerted. Now, that is also applied to the domestic violence restraining orders in family court, but family court also expands into other behaviors such as harassing behaviors. A very common one are, we all love our phones, right? Text message. We get
the good old mean text domestic violence restraining order.
You get to be a keyboard warrior against your, former significant other, your current significant other, whatever the situation is. You'll start doing incessant ones. I have one where it was the woman doing it. She knew that he was sleeping. They had an argument. He went his separate ways. He went to stay somewhere else, and she stayed up all night, texted him constantly these mean, nasty texts. And she kept doing that. Every argument they had, There wasn't necessarily physical, but she would not leave the man alone. And that is domestic violence under the family code for a domestic violence restraining order. There are other things such as coercive control.
That's the big one. 2020, we added that.
Yes. So that can be the code that this is under. It even says including but not necessarily limited to. So really, it's still open to interpretation. It's going to be very fact-based. It's going to be, as they like to call, the totality of the circumstances. That is a term that us lawyers love, and whoever writes the laws loves, because always totality of the circumstances. It's that catch-all.
Depends on your judge a lot of times.
Yes.
That's a big challenge, because burden of proof when you're in family court is that preponderance of the evidence. I always explain it to clients. It's 50% and one feather. It's a credibility contest.
Yeah.
And I think that if you ask anyone, you even ask attorneys, what is coercive control, you would struggle to have a coherent, short, simple answer for it. And the judge has, like I said, totality of the circumstances, has a ton of discretion.
Well, and some things that it does include descriptions of, or at least examples, is that, say, one party is controlling the money. They're, they're controlling the purse strings, make it so that you can't leave. You can't. Yes.
Electronic. There are some things listed, but it's
yeah.
broad.
Well, here in California, it comes up a lot because people, they get in their heads and they want to assume people's nationality, and immigration status, but that also gets factored in here, where if you try to threaten somebody else's immigration status, whether it's they actually have that or not, but it's more of the intent, what you're trying to do to the person. If you're trying to make them fear, whether, even though they could be safe, they're totally good, they're totally great, whatever with their status, but if you're threatening it to them, that right there can be used as domestic violence for the restraining order.
And as a public service announcement, it is literally in the family code. Immigration status is irrelevant to custody.
Yes.
The number of times we get asked that question in the state of California, we get it. It may be problematic other places, but in family court, it is irrelevant and probably one of the easier ways to piss a judge off.
Yes. Because why should someone's immigration status affect whether or not it's the best interest of their child to have contact with that parent? The idea that someone would think that's important is just beyond ridiculous, and it just shows the mentality of that person. And that's basically a little, beeping red flag, red alert to a judge going, oh, they're not to be believed themselves, because if that's where their mind's going, I can't really trust anything
They're
else.
They're going to throw everything out there. Because it's like, a lot of times it's you've dated this person, you married this person, you've had some sort of life with this person. And I always explain to people, I'm like, when they make these accusations, oh, he uses drugs, she does this. Well, my probably favorite story, and I tell this story all the time, in court was we had a client who had a drug problem. He'd actually been to jail. He'd been out of jail for about 18 months. And we get into court. He'd had significant contact for given the circumstance with their child. And we got the judge to say, hey, we're going to do 50-50 week on, week off custody. The other attorney freaks out and says, he's a drug user. He's high all the time. He planned this. And we're like, we'll take a drug test today. Oh, well, he knew this was coming. He could plan for this, all these things. And then I just kind of quietly lean up to the microphone and I'm like, Your Honor, these two met in rehab. And the judge, who I won't name her, but we're in front of her regularly, pans over to the other attorney who's not a local counsel and looks at her and says, is this true, counselor? The attorney kind of tail between the legs. I believe so, Your Honor. And they send us out in the hallway. Like, a lot of times these people make these complaints, but you don't date. You don't hang around people who are not alike. If you're not a drug user, you don't go hang out with a drug user.
Let's be fair. The old saying, birds of a feather flock together, is a real thing. Yes. Do you think that, like this complete straight arrow is going to end up with someone who's constantly breaking the law and whatever it is? They don't have enough in common to be together. Now, if they were together, they both were clean, one gets injured and develops, like, for example, an opiate addiction because of their prescriptions, that's something else. But not usually what happens anymore. And then to try to later, when it benefits them, to throw that in their face, we do see that a lot.
And I've seen this go against our clients. I was in court in Riverside, and we had a client who they had known the opposing party, and they had dated 15 years prior. And they had broken up, and the opposing party had had a couple kids with someone else, and then they had gotten back together. Well, our guy was clean now, but he knew that this woman had lost her other 2 kids to the Department of Child and Family Services. And actually, the same judge I made the drug argument in front of, I was like, Your Honor, 6 months ago, this woman almost lost her arm because of her drug use. She would test dirty today for a number of drugs. And she looked at me and she's like, so you're telling me they knew each other for 15 years, he knew about all this stuff, and then he chose to have a child with her, and you want to now use that argument?
Yeah. They were okay with it the whole time.
Yes.
Where I hear it, another example of how people use the same kind of idea is I find a lot of times when it comes to finances, right, especially if someone's self-employed, and it usually happens like doctors as clients or whomever it is, and the woman's now like, well, he's underscoring his income because those are not real expenses. Those are personal expenses that he's claiming as business ones. I know what he's doing. I'm like, the reason why you know this is because you benefited from it while you were together. You condoned it. You were completely fine with it. Now you want to take the moral high ground because you're no longer benefiting from it. It's actually potentially hurting you for support purposes.
Well, we'll have our clients like, she'll be self-employed, cash business. Oh, well, she makes so much more money. And it's like, shut up, dude. You're admitting to tax fraud in open court here. Yeah. Like, we're not going to talk about that. So it's like this catch-22.
Yeah, but it shows if you can show that the other party is now trying to flip that, we're totally fine with the behavior, whether it was they were both using drugs during the time, where they were both, committing tax fraud, basically, allegedly, doing that while together. And then suddenly when they're no longer benefiting from it, or now they can turn the table and accuse it, now they want to use it. It always reminds me of, like there's a legal argument with the Latin, like, res judicata, where it's like, in my head, I'm like, well, you're fine with that this whole time. In law, it's more of like this has already been, heard by the court, a chance to argue it. And my mind still goes to that because, like, you already addressed this in your life. You were fine with this. Now, suddenly, when you're wanting something else, now this is suddenly bad behavior that, oh, no, judge, you need to completely condemn them, even though I did it with them. But now you need to really condemn them for it.
Well, we go back to the DV piece. And with DV and preponderance of the evidence and the discretion of the judge, when you have arguments like this, when you have things like, hey, they use drugs, so they're predisposed to doing this. Okay, well, you've known them for 7 years. You were married to them for 4. They were using drugs while you're together, and now you want to use it against them. It could harm your credibility.
Yeah.
And DVs, just to be honest, for better or for worse, with the way we define domestic violence in California, it's a credibility contest.
Yes. And something I always tell clients about credibility is I kind of have like my own personal, what I call 2/3 rule of thumb, which is whatever you're talking about, because someone's testimony, just their words, that is evidence. A lot of people forget that because we're in the day and age of DNA and all this physical evidence, and which is actually not direct evidence. Direct evidence is your word for it, even though studies show eyewitness testimony is the most unreliable evidence ever. But it is still evidence.
7 witnesses, 7 different stories.
Right. And so what I explain to clients is that if you can corroborate, no matter how big, how small, if you can corroborate 2/3 of what you're saying, that gives you credibility built up for that remaining third that you cannot possibly have anything to back you up. And the same thing when we're looking at the other parties, the woman's story, whatever we can, if you look at the other way, of what can we show that shows that she's not being credible. Like, for example, if she says, I called him or I received this call on this day and time, and you have your phone log showing, really, here's all my phone logs, I did not make a call, what's she talking about? Yeah. Whatever it is, even if it's small like that you can provide either to take away their credibility or add to yours, I think it's a good thing. And as it builds up, because it's all down to that, and the more detail you can give, the better.
Well, it's you think about it, and it's usually there are not many good eyewitnesses in DVs. Usually it's, hey, mom saw me, sister was there, brother was there. But well, the way it works in court is they're excused from the courtroom.
Yes.
If you and them tell the same exact story, that can add credibility. But if your stories don't line up, that can destroy the credibility of your story.
Yes. And I have I don't like to call, because like we're a different standard of proof, like you mentioned, it's preponderance of the evidence. You said 50% a feather. I've always heard either 51% or 50.1%, you know, where it's like just that slightly. But
one irrelevant fact can turn a DV.
Yes.
That's the clear point.
Yes, it is. And again, it's back to the totality of the circumstances, which is just shorthand or code for I'm going to put everything in this pot, sift it out, see what comes out, and kind of just go with that. But you always have to address everything. I don't like to just pick one theme and go with that, because the judge is looking at everything. You never know what the judge is going to find more important than other things. You don't know if he's going to interpret it the same way, because like you said, 7 people witnessed something, 7 people have 7 different perspectives, and it's all based on their experience, their how they heard something, whether they even heard the same thing you did, whether they're looking at the person. I was watching one trial for somebody else, and when a certain non-party got brought up, I saw the other party turn and glare at somebody in the audience. I'm like, oh, that's a trigger. What's the story there?
Yeah.
And the judge didn't see that. She wasn't looking. Why would she be? She was looking at the witness. And this was something that came up with one of the parties. And there's always a perspective and literal point of view that way as well that can play into how someone sees something. So you don't know what the judge is going to catch and what you're going to catch, and so on. And
I'd like to get your thoughts on this. My theory with vast majority of restraining orders we're involved with, we defend.
Yes.
Representing men, and 95% of restraining orders being filed by women mean that we are we defend restraining orders significantly more than we prosecute. We probably defend 5 to 7 restraining orders as a firm a week. And we prosecute maybe one a quarter.
I've done a couple.
Yeah, it's few and far between. But my theory and my strategy always, a lot of times we'll get guys, we need to get the response in. We need to get a response. We need to respond. My theory is, don't respond.
No,
We're not going to put words on paper.
Yeah.
You're not going to have to get up on the stand and corroborate or be viewed as being truthful to what you wrote. What is your theory on that?
Okay, that is something that's very important. I do not like filing responses on domestic violence restraining orders. Now, to kind of give an idea of why, there's a couple different things. Domestic violence restraining orders and those requests are different than other kind of requests that we deal with here in family law. Yeah. So like a regular request is just a request for order, what we commonly refer to as an RFO, right? Those are like child custody, child visitation, just like regular things, child support, whatever it is. And if you do not file a response, they can actually do a default against you. Now, those are just completely civil, though. The domestic violence restraining orders are what they refer to as quasi-criminal in nature, which means you have the right to remain silent. So even if they are alleging that it's just harassing text messages, which doesn't fall under domestic violence for the criminal code, but it does fall under the domestic violence restraining order code under family law, you still have the right to remain silent. So they cannot force you to file a response. That's more of the law part. Also,
filing a response different than putting your story on in court.
And I'll talk about that as well. But let's talk about the more of the filing thing. So also, what's different about domestic violence restraining orders versus, say, other civil things is that it is not what's referred to as a pleading requirement. So, for example, the person, let's say the woman, because that's more often the case, she's not required to put every single incident of alleged domestic violence under the code that she's going to talk about. She can just say, he pointed a gun at me and he made some threats, and this is not the first time it's happened. Mm-hmm. Well, now she can bring up anything she wants to about that at trial. She's not limited. She opened the door. And you don't know what it's going to be.
That's a credibility piece. That opens the door for a very big credibility play.
But there is case law that says she can do it. And that is something as a way to combat that at trial. Yeah. Going like, why, if this was so much of a concern, if this was real, why didn't that come to mind that she put this in there, at least giving me some more examples, right? But that is more of an extreme example that I just gave of what she can have it. But the point is, she doesn't have to put everything in there. So if we then respond in writing to that, one, she can change her story. She can move the goalpost on us. She can start adding other things that we still don't know about.
Trial by ambush. I tell
Yes.
people it's one of the last bastions of trial by ambush.
Yeah.
When you're on the receiving end of a restraining order, you don't have to give them a damn thing. You can show up and put on your defense, and that for the most part, there are a little bit of carve outs.
Yeah.
But you don't have to give away your strategy.
Yeah. But really, even if you're the one that's trying to get, I'm going to say DVRO, it's just shorthand for domestic violence restraining order. If you're trying to get the DVRO, because you are not required to list everything out, the only thing that you have to provide prior to your little trial to be able to not be ambushing, right, is that you have to provide a witness list if it's more than the parties that are going to testify, and you have to provide an exhibit list of the items that you're planning on presenting as evidence in your case in chief. You don't, if you're planning on something as a rebuttal, you don't have to include that. But if you're just going to have testimony, that's how you're going to ambush.
Very little, even with a witness and exhibit list,
Yeah.
you don't have to provide a whole lot of context.
No.
And little secret about that also, as attorneys, we know just about every piece of evidence you can probably wiggle it in as a piece
Yeah.
of rebuttal evidence and not have to disclose it beforehand.
Yeah, there's a lot of wiggle room. On another one, I got a video in that wouldn't necessarily be in, but I got her to open up the door, and we were able to get it in, and it was one where arguably the video shouldn't have been recorded in the first place, and it had her laying her hands on him, and that had ended up having a lot of weight with the judge, and also her trying to keep it out after she opened up the door had a really negative impact for her with the judge. He did not like that. He's like, well, if we're being honest, if you're being honest, you could tell he was thinking this with how he was choosing his words. He was not appreciative that she was trying to keep that out, especially when she laid her hands on him.
Well, and I think the funniest story I've ever heard about this is we have an attorney who had a DVRO that it was centered around an Instagram video. And I know in our attorney chat we talked about this. I think even the picture actually, when everybody was helping with strategy, but the center of the DVRO filing was a bruise on her neck collarbone area. And
is this the one I think it is?
Oh yeah, it is. Oh yeah, and our guy,
The manufactured evidence.
Well, so she manufactured it, said it was this. So somehow, I don't know the details. I don't know if we ever asked the question, but he had access to her Instagram messages. She was cheating on him. And she had sent the same photograph to a guy saying, look what you did to me. And we'll just say it was exposing some things that you'd get arrested for exposing in public. And we were able to just ambush her in open court. I'll just say it. There was topless picture of her, hickey on the neck, telling it to another guy. And we didn't have to disclose that because she ran through testifying that he hit her, he did this, he choked her, he did all these things. And then we put this out there. And the case is basically over after that. If I remember correctly on that one, after that piece of evidence came in, the judge asked the attorneys to go out in the hallway and have a conversation.
Unfortunately, and a little bit amusingly, when you're past the case, like a hindsight thing, but I don't understand, but so many women, I've heard stories where they try to use hickeys as evidence of being harmed, about being like, choked or whatever. Like, in this day and age where people are a little more inventive or, with how they, it's not the run-of-the-mill vanilla anymore, right? And there could be marks that way. But no, it's always the hickeys. I'm like, how are hickeys looking like?
I think
it's just
there's
a
an
common
irony
one.
now,
Yeah.
and I think you see it more and more now, is the woman getting caught cheating and then being the victim of domestic violence. I feel like it's been on a weekly basis where a guy has come in. We have a client who the woman has been caught cheating, and all of a sudden the relationship she was in was full of domestic violence.
Yeah, it can get weaponized pretty easily, especially if there's children involved.
Used as a sword instead of a shield.
Yes.
Restraining order was designed to be a shield to protect the person and the children from an abuser.
Well, and so this is my personal experience, professional, I should say. I have no statistics on this. It's just an observation that I've made, completely anecdotal, okay? What I have seen is that when a woman is the one that's more likely to commit and has been committing domestic violence, she has been the most likely to lie about it. She will be, this is, again, strictly my experience, she will swap it around. and what she's doing, she actually shows that she'll say it's him. Like, he grabbed me here. It's like, actually, that was you that grabbed him there. There's a video comes out later or something like that, evidence of that. Or she will often leave out that she was hitting him, doing all this clawing at him, all this stuff, and all he did was try to shove her away to get away from her. She'll leave out all of her part and say, and he shoved me away. We were just talking. I'm like, you left out all this part. And then there's evidence that comes out that she was doing those things. And so I always, whenever I have a client that he's been accused of domestic violence, I go through his history. I don't go just over what she talks about. And I always want them, of course, to touch on that, what's true, what's not true, what's taken out of context. But I also try to find out, what is their real history? Has she been laying her hands on him? And if there is good evidence for this, I will actually do a counter domestic violence restraining order against her. Because
Key point, restraining orders are one way. Unless you file your own domestic violence restraining order, it is irrelevant what your allegations of domestic violence. Well, it's not irrelevant. It can go to credibility.
Yes.
But she filed a restraining order. She got a TRO granted against you, and you present evidence that she committed domestic violence. She's not getting a restraining order.
No, not as a result of that trial, unless you filed it as well.
Yeah.
And as like you said, it can go against the credibility of her, and just gives the court a better story. But there's no request in front of them to go the other direction.
No.
And also, say she gets this comes up a lot, and I do want men to be very careful of this. The woman, if she gets a domestic violence restraining order against you, and then she violates it by contacting you, she's not violating it.
Yeah.
It was something we would want to know
Unilateral.
to be able to bring up, going, hey, she must not really want this, or she might not be really scared because she's violating it, but she's not going to get in trouble for that. So often have I heard men say, well, I thought it was safe to respond to her because she reached out first. Like, no, don't. That you have violated. And even if we get to trial and we get to the point where we prove, even though the burden's on her, we prove that everything she alleged is not true, and that the court would have said, oh, hey, you're fine, request denied. If you violate it, that right there, by law, is enough for them to say, you violated the temporary restraining order, there's now a permanent one against you.
Yeah. If you wouldn't have responded, a very strong piece of persuasive evidence would be that she's reaching out to you.
Yes.
She gets a TRO granted, and then 4 days later, after you get served, she texts you like, hey, do you want to see the kids? We're going to go to the park. If you don't respond, and I get it, it's challenging. If you have a kid, you haven't seen the kids in a week, it's going to be another 2 weeks. It's really hard. But that's a strong piece of evidence that there's no fear of ongoing harm, which is what really they're trying to prove to get a restraining order. So it's counterintuitive, like, oh, I can respond to them. But if you don't respond, that's a very powerful piece of evidence we can put in.
Yes. And also, to be clear, it doesn't have, if he were to respond, it could be completely peaceful. It could be like a thumbs up, to like accepting wherever she is. It's still, you responded back. You had contact. Because the no contact is you're not allowed to contact them directly or indirectly, which also reminds me, so often a person, because they're trying to keep the peace, they want to see their kids, or, they will try to send a message through a family member over to her.
Sister, brother,
yes,
grandma,
and just saying,
mutual friend.
They're saying that, it's very peaceful. It's very, like, hey, I'm so sorry. Like, I'd like to work this out. It doesn't matter. You violated it. It doesn't matter whether it's aggressive, whether it by itself would be enough to, obviously it'd be worse if it's aggressive one, but just the mere contacting, violating that no contact order, the restraining order, is enough to be used against you, and also opens yourself up to getting arrested.
And I'll say this, I've seen very, very long, drawn-out, hard-fought restraining order hearings that come down to the simple fact that you violated the temporary restraining order. Yeah. Attorney's able to knock down all the accusations, discredit all the accusations, but the court has the ability to look at it and say, if you could not follow the temporary restraining order, then that shows me, in totality of the circumstances, that some protection may be needed.
And bringing it back, if there are children, that is now a finding of domestic violence against you, and now there is a rebuttable presumption that the burden's on you to prove that the presumption is that you should not have legal or physical custody of your children, and that you should not have any visitation unless it's supervised by a professional monitor. That's their starting point.
Yep.
And it's all because you violated, even a peaceful way, of the temporary domestic violence
showed up
order.
at the house to grab some things, sent a couple text messages.
Or just responded to her text.
Yeah, definitely.
So it's really obey the law. And even if, because this happens so often where the guy's like, well, I'm just trying to be peaceful and she's violating all these other rules. That, there's a court order that says that if you do X, Y, and Z, then you can have your custody taken away from you. And I'm like, yes, it says that because it's more of a warning. But the courts, unless they keep telling the person and seeing it for themselves and keep having to come back to court where they keep having to address the person saying, hey, you really need to follow my order, the court's not likely going to do anything about it when it's the woman. They have a shorter, lower tolerance for it if the man is doing it. And unfortunately, people get in their head that it's women that are harsher on men. It's not. I find that it's usually the male judges that will hold the men to a higher standard than they will the women. They'll be harsher on the men. They'll interpret the men's actions a lot more negative light than they will a woman's.
Yeah.
And I think it's a combination of, because I also did criminal law. I was a prosecuting attorney in Indiana as well as I did defense. I did that for like 10 years as well as family law for the last 8 years. And I've noticed that in the court system, whether it be criminal or civil, people don't have a high opinion of women. They either think that we're too stupid to do crimes or that we did it because of a man or all these things. So they think that we're too emotional. So therefore, like we're children, like, oh, fine. Just like we just have to keep telling them and they'll finally figure it out that there's nothing. But men, you're held to a higher standard. But also I think it's a combination. There's a study, I remember it, I can't cite it, but I can find it probably, where if someone went through the same experience, the belief going into the study was that someone who's been through the same experience will be more understanding of the next person going through the same experience, and they'll understand and they'll show them grace. Opposite came out. So if I've been through something, whatever this experience is, and then the next person's going through it, the study found that I'll actually more likely hold them to a higher standard and kind of forget all the difficulties that I had, all the obstacles I had, and I think of them as much lower for this next person, like, why can't you get over that hurdle? It's not that hard. I went through it. I did it. Why can't you?
Definitely.
And I think that maybe that's my theory of why some of the male judges are more likely to hold men to a higher standard, because they're thinking, well, I would have handled it differently. Why didn't you? So if you're not handling the way I'm in my head imagining that I would, then there's something wrong with you.
Yeah.
That's just my personal little thought process of what might be going on.
It tracks. Well, Shannon, thank you so much. A lot of really, really good information for our viewers and listeners about restraining orders, domestic violence, everything we've covered today. For our viewers, for our listeners, thank you for watching. Thank you for listening. I'm out. We'll be back next week with another episode of the Father's Rights Playbook.